case number 133, People versus Antonio Aragon.
Good afternoon, Your Honors. Harold Ferguson for Appellant Antonio Aragon. We'd like to reserve 2 minutes for rebuttal.
You may.
Your Honor, this is what you would characterize as an ipsic-dixit complaint. They're charging him with possession of metal knuckles because the officer says it's metal knuckles.
Well, the officer said it was brass knuckles.
It's
right?
brass knuckles, metal knuckles, but there is no physical description of it. There is nothing in the complaint that indicates...
How would you describe it, counsel, to make it sufficient?
A physical description of what it looked like. And I don't know what it looked like because we don't have any description in it.
Well, isn't brass a metal?
Brass is a metal, but it doesn't indicate that there's nothing in it that says, other than his conclusion, that this is brass knuckles. There's no physical description as to the size of it, whether it was wearable on the hand.
Is that required?
I believe some type of physical description is required, and even if it isn't required, there had to be something that indicated how this police officer indicated that he knew that this was metal knuckles. There is not the standard thing.
And what would that be based on?
That would be based on his training, his expertise, his experience with it,
Recognizing what a brass knuckle is?
recognizing what a brass knuckles
Is that required if it's common knowledge, it's not something that requires special training? Or
I don't
experience?
believe this is common
Well,
knowledge.
no, but if it was, then would you require in the accusatory instrument that the officer say how he...
If it was
she
something
knew?
that was within common knowledge, then no.
So isn't that really the question, whether it was or wasn't within common knowledge?
And, Your Honor, as my appendix shows you, if I was so certain as to what constituted metal knuckles, I wouldn't have produced an appendix of pictures of items that are sold as metal knuckles. I would have brought a display of items here, laid them out before the court, and said, some of these might be metal knuckles, some of them aren't. I can't tell you, based on what I pulled up from Amazon.com, what of those items constitute weapons and what don't, because there is no definition.
It's an iconic, it's sort of iconic, right? I mean, all you pointed out is that there's this familiarity with metal knuckles, that they get used for all different kinds
They're
of
used
things,
for all-
on bags, on boots, on belts, on whatever. But for purposes of the statute and what the statute means, brass is telling you it's
Brass-
metal, and it's a particular type of metal. It's telling you knuckles, which is referring to a part of the body, is it not?
But then again, Your Honor, all of the items in the appendix are listed as brass knuckles. They're listed in, and they're sold under that description. Some of them have things that could be worn on the hand. Some of them aren't. Some of them have holes in them. Some of them don't. Some of them could fit in a pocket. Some don't. We don't know from this particular complaint what this item looked like.
Counsel, this is a sufficiency case, right, for a complaint.
That is correct.
Not an information. It's not really an issue as some of these other cases are, Talbert, I think, or the others, of is this a lampshade or are these brass knuckles? I mean, you can make that motion, you could have the things examined, and that's, you can see, does this fall within the definition of the statute? This is a pure sufficiency of the document case, right?
It's pure sufficiency of the document.
It's not really a question of, if we put these things on the table, is it an earring or are they brass knuckles? So in that context of this complaint, which is a different standard than information, right, is this sufficient? Why isn't it?
It isn't. There is no physical description of the item. There's nothing that indicate how this officer came to the conclusion that this item constituted medical knuckles, and there is nothing talking about his training, experience, or expertise.
Well, what would he have said? That it weighed, you know, something, I picked it up and it weighed like it was metal instead of, you know, plastic that was painted to look like metal, or?
That it was something that was wearable on the hand, that fingers could fit through the holes, that it could be used as a weapon, something on that type of description. I mean, you see the distinction
Well, there are
between...
probably some fingers on some really small people that would fit through small holes, so whether it would fit on anybody's hand or just a hand.
I think that it would fit on a hand, a sort of standard hand.
What's a standard?
Well,
Why isn't that standard brass knuckles? That's the point.
because there's nothing in here that tells that that's what it is, other than
Because Amazon.com sells you boots that have brass knuckle, little iconic graphs on it.
But there are all sorts of items. In other words, you're
thing
referring
is,
to
though,
something that that has never been defined by an appellate court, that was not defined by the legislature, and things change over time. What constituted something 100 years ago and was known as that is not what it looks like today. 100 years ago, none of the items that I have in my appendix would have existed. They all exist now, and they're sold under the term brass knuckles. We do not know what the item looked like that was in my client's pocket. And going back to Judge Garcia's question, we don't know how he came to that conclusion. Did he have any experience?
Going back to the sufficiency point, as opposed to is this really this or is it not, right? As some of these other cases look at, sufficiency seems to me aimed at two things, right? Double jeopardy, and I don't think the argument here, one, it's a complaint, so he'd never be tried on this, I think. It could never go to trial on this complaint. But double jeopardy, there's time, there's place, there's item.
Right.
And notice to prepare a defense. So I mean, it couldn't go to trial on this. So the notice to prepare a defense claim, I don't know where that fits in here. But don't you have enough notice to prepare a defense? And don't you have enough information to protect the defendant against double jeopardy issues?
I don't believe so, Your Honor. And I think the distinction is, if you take a look at, this court has required an explanation in Dryden of
That
what
involved-
was the officer's
Counsel,
expertise in an
That
area.
involved a different type of
It
per
offered,
se weapon, right? The gravity knife, and that is something that you can't look at and say whether it's a gravity knife. Most people can't look at it and say that. You have to do something with it. You have to flick it, you have to do something to make sure that it does come out like a gravity knife. And so someone like a police officer who might have some experience with that, I don't think I can just look at somebody's knife and say, oh, that's a gravity knife.
and my position is, you can't look at something I can't look at something and tell you whether it is or isn't brass knuckles. But, Your Honor, taking gravity knife away, I think all of Your Honors, if a package of marijuana was laying in front of you, you would be able to say, that's marijuana by looking at it.
Not me.
All right, but the courts have all...
I'm taking the fifth, then. I'm not missing anything
But
then.
consistently, the courts throughout the state have required in an accusatory instrument concerning drugs that there has to be something that indicates that by the officer's training, expertise, and experience, that he can say that this item constituted drugs. Well, that's what we're asking for here. There is nothing in this
Right,
particular
but
complaint.
the word marijuana doesn't tell you what, any of the nature characteristics of it, so it's not gonna help you to just say that, right? If you just see the bag, it's not gonna help you. But knuckles is telling you something about the item, and brass is telling you the type of metal alloy.
But that's...
Why isn't that enough?
But that's simply a conclusory term. All it is a conclusory term here. It's something that hasn't been defined. If this court had provided a definition as to what this item was, then maybe it's different. But we don't have that. And all you have here is a complaint that makes a conclusory assertion that what I recovered was brass knuckles.
So what if the complaint said that I recover a silver chalice? What would that require? What description other than it's a chalice and it's silver would that require?
First of all, it's not.
No, it's not a weapon, but,
it's not
you
a
know-
weapon, but that a chalice has a specific term, and a chalice is a chalice. Here, there are many things that have been characterized as metal knuckles or brass knuckles that don't constitute a weapon.
Thank you, sir.
Thank you, Your Honor.
Counsel?
May it please the court, Philip Morrow for the people. In light of defendant's waiver of prosecution by information, the misdemeanor complaint here is judged against the reasonable cause standard. The officer's factual allegation that he recovered one set of brass metal knuckles from defendant's front pants pocket satisfied the standard as it provided reasonable cause to believe the defendant committed criminal possession of a weapon in the 4th degree by possessing prohibited brass metal knuckles. Defendant claims that the misdemeanor complaint was deficient because it did not include more detail about the brass metal knuckles, but metal knuckles has a commonly understood and obvious meaning such that little more need be or could be said.
What about counsel's point about all these different iterations of metal knuckles when he goes on the internet and pulls up all these things?
Your Honor, the printouts in defendant's appendix, I think that several of the judges pointed out that all of these different products actually have the same motif or image on them, such that it actually reinforces the idea that people understood what is meant by metal knuckles. And another important thing to consider is that these things aren't being sold as brass knuckles. It's a brass knuckles luggage tag or handbag or shoe, and I don't think there's any risk of people confusing a bar of soap with an actual set of metal knuckles. And the fact that
I kind of view the items as similar to items you would see. There are knives, and then there are plain knives, and these things seem to be combs, luggage tags, bottle openers, iPhone cases, and then fashion items like boots, shoes, belt buckles, and cufflinks. Those are the things I saw on there, and those items, for sufficiency purposes, as Judge Garcia was saying, seem to be clearly not what we're talking about here.
Exactly. And as Judge Garcia pointed out, this case concerns the sufficiency of the misdemeanor complaint.
If he had one of these luggage tags in his right front pocket and he was arrested for possessing brass knuckles, would that be sufficient?
Well, if he possessed the luggage tag in his pocket, the complaint would be sufficient, as it would allow him to prepare a defense and it would protect against double jeopardy. But the solution there would be for him to have the court inspect the item and say, this is clearly not a weapon, it's not a set of metal knuckles, and then ultimately whether something is metal knuckles is a question for the fact finder. So here we're at the beginning.
So he'd go to trial?
Yes, he would go to trial.
On a luggage tag?
And he would almost certainly win.
Almost certainly. Well, I mean, this is, pick up on your opponent's point. I mean, jurisdictionally, you've got to describe it sufficiently so that I'm going to trial on something that's a real crime, not something that I've got to make an affirmative defense of.
Oh, exactly. But, here, given that metal knuckles has a well-understood meaning, I think that was enough to allow the case to proceed. This case is different than a gravity knife, where you have a technical and complicated penal law definition. You can't tell whether a knife is a gravity knife unless you test it. So, they're really, without that additional detail in the complaint, you wouldn't be able to tell whether it was a legal knife that anyone could have or an illegal knife. And the controlled substance cases, if you just had a white powder in a bag, that doesn't give you reasonable cause to believe that, say, it was cocaine. There might have to be a little bit more to meet that standard. And the fact that there's no definition of metal knuckles in the penal law reinforces the idea that people understand what it is. And when the legislature amended the penal code to ban the metal knuckle knives and plastic knuckles, they used the term metal knuckles in the definition of those other weapons, understanding that people would know what they meant. And I would say, too, that the absence of authority from the appellate courts reinforces the idea that people understood what is meant by this term. But the bottom line here is that the complaint had to give defendant notice of the charges and protect against his right to double jeopardy.
If the defendant had exercised his right to go to trial, you would have converted that accusatory instrument into an information?
The accusatory instrument actually was converted to an information before defendant pled guilty. He waived his right to prosecution by information at the plea proceeding. So that actually did happen here.
And did the description remain the same?
The description did remain the same, yes. But in the cases that are discussed in the briefs, Singleton and Laguna, I believe, the defendants in those cases challenged that what they possessed was actually metal knuckles, and the court inspected the item and then rendered a decision. So there were options available here to the defendant if he,
Were they available for inspection?
in his demand to produce, defense counsel requested the right to inspect them, yes, and that would have been an option available to him.
So why isn't defendant correct that it's insufficient because the officer failed to give a reason why the officer was certain that these were brass knuckles within the meaning of the statute? Why doesn't the officer have to make a reference to training or experience? Is it that it's just so common, everybody knows what this is?
I think that's it. There's no particular training or experience that an officer would need to make that determination because it has a well-understood and common meaning. And just to take an example, if it was illegal to possess a tennis ball and an officer said, I recovered a tennis ball, you wouldn't need to describe it because everybody knows what it looks like. It's yellow, fuzzy, it's got the lines on it. And here, people understand metal knuckles as, a metal weapon that's worn across the knuckles. So I don't think that you would, I don't know what training or experience you could even have to make that in the complaint. It's definitely not like a gravity knife. But if your honors have no further questions, we rest on the brief. Thank you.
Thank you, sir. Mr. Ferguson?
Just 2 points. What's coming up next is the Billy Club case that you're dealing with. And there was a physical description that was contained. And that was another undefined weapon in the particular statute. And yet there was a physical description. We're asking for the same thing, too. And the other thing is, when your honors go back to chambers, if you would look through my appendix, each of you individually, and look at the 100 items, and ask yourselves which of these items are a weapon and which aren't, if there would be a unanimity amongst you that you could determine that each of those items was or wasn't a brass knuckle weapon, then I would have no issue.
Doesn't that go to the people's argument that if you question as to whether that specific item was, you could have it inspected and challenge that item?
No, Your Honor. I think what it goes down to, there had to be some type of description so that he was able to defend himself, and we didn't have that here. All we had was the conclusion of an officer with nothing else. He said, it's metal knuckles because I say so. Your Honor, I don't believe that's sufficient.
If he just describes it, if the officer just describes it without referring to training, would that have been enough?
It would
Or
be a
gives
lot
more of a description than what they
more than the
gave here?
description. We've been in a lot tougher position, but I think you need it both. That he has to have some type of experience so that he could indicate this was or wasn't. But I believe you needed at least a description and something that indicated how he knew. Thank you, Your Honor.
So someone without law enforcement training will not know what brass knuckles are? Is that what you're saying?
I know for a fact that as I went through all of this, I can't tell you which of those items are weapons and which aren't. I can have a pretty good idea as to some of
Well,
them.
many things can be used as weapons. The
Many
question
things
is, are
can-
they these per se brass knuckle weapons?
Right, but I mean, even things like what are carried that you can have as your iPhone cover, I can envision sticking my fingers through and using it as a weapon, and yet it's marketed as a brass knuckles iPhone case. So if I, after looking through and becoming an expert.
Following up on what Judge Rivera just mentioned, if you were the victim of a crime that was committed by someone with brass knuckles and you described what you were hit with, you would say they wouldn't know what the brass knuckles were because they don't have experience and training with that because they've never been a victim of brass knuckles?
No, because it was how it was used. It was something that was worn on the hand that he was able to use in an offensive manner that had no other reasonable use. Here, we don't know whether it did or did not have a reasonable use. We do not know whether this particular item was wearable on the hands. In the situation, Judge Abdus-Salam, that you're talking about, you were struck by the person wearing the metal device on that person's hand. You know how it was used. You would be able to describe it. Here, we don't know whether this item fit on his hand or not.
Thank you, sir.
Thank you, Your Honor.